I think it's fair to say that when most people think about lawyers' fees, they think this is going to be expensive.
They want to win those disputes, and to win those disputes they have to pay the top lawyers, and the top lawyers charge a lot of money because they're often worth what they're charging. I think it makes common sense that there is an interest in a lawyer prolonging a dispute, because whilst ever that dispute is going, they're making fees, and at the end of the day it's a business.
Is it really difficult, or is that just a cop-out? So today I thought I'd talk to David about a few different things. We might break this into segments. The first one was just about legal costs, and are they too expensive? Why are they too expensive? What can you do about it? The second thing is about barristers and the value of barristers and what barristers do. And the third thing is about resolving disputes and how you can actually get out of litigation or get out of these disputes in a more effective way. Get back to normalcy, I suppose, if you happen to be in that situation.
Sounds good, Adam. Looking forward to it.
Thanks, David. So I'm talking to you because you are an expert at legal costs, and
Yes.
this is a topic about legal costs. And I think it's fair to say that when most people think about lawyers' fees, they think this is going to be expensive.
Absolutely.
Why do you think that is?
Well, they have a history of charging a lot of money to a lot of people. That's their business.
Yeah? But why is it, there are a lot of people that charge money, but why is it lawyers especially that seem to have a reputation for charging a lot of money?
Well, I guess the average person sees it as a lot of money. A lot of lawyers represent commercial interests. If you represent an ASX listed company, by way of example, they usually have a lot of money in the coffers to pay for lawyers, and a lot of their disputes involve big numbers. So they want to win those disputes, and to win those disputes they have to pay the top lawyers, and the top lawyers charge a lot of money because they're often worth what they're charging.
Tell me, when you say a lot of money, what that actually means. Give us some numbers.
Well, the better senior counsel can charge you over $20,000 a day, which I regard as a lot of money to myself, but to an ASX listed company they may not regard that as being a lot of money. If that senior counsel can produce the result that they want, then it's well worth their while, if the dispute could be worth several millions of dollars.
Can a senior counsel who charges $20,000 a day produce the result?
Well, that's why they charge that much money usually, because they can produce that result.
And they do.
Quite often, that's right. You get the right senior counsel and you may well win a case that a lot of other counsel or solicitors won't win for you.
And then that counsel, if they charge $20,000 a day, how much involvement would they actually have in the case? Because they turn up, obviously, at the trial. They might have to prepare a little bit, but, as you know, there's a lot of work involved, preparing documents and so on. Do they participate in that too?
Well, it depends on the senior counsel, and usually a senior counsel will have a junior counsel which will assist them, and the junior counsel will do the legwork, such as preparing an affidavit, and then the senior counsel will look at that and change it if he or she thinks that's appropriate, or perhaps add more information. It's the same with pleadings. They may add a whole new sort of claim or cause of action against the other party that no one else has thought about. And the reason they do that's because they have more experience, and they perhaps have better vision of what is actually potentially involved in a matter.
Do you see a correlation generally in your experience between people who charge more and their quality of the results?
Absolutely.
Really? Is it a direct correlation?
Not always, of course, but in most instances, if someone is charging more money, they're generally more effective at what they do.
And let me ask you this question. How many solicitors do you think there are that accurately represent what the costs are going to be in advance before a case starts?
I think it's difficult to predict how much costs are going to be at the beginning of a matter.
Is it really difficult, or is that just a cop-out?
No, I think it is difficult because, there's your bare bones type of matter whereby things are very simple. Each side prepares an affidavit or two and you go to hearing.
See, I actually don't agree with that it's difficult. I mean, everyone says it's difficult. and that's I actually think that's a cop out. You run with tax cases, for example. I mean, granted, it's against the tax office, but if you really needed to, you could work out roughly how much it's going to cost, and you could do it pretty accurate. You could do it pretty accurately.
Possibly, but I mean, if you're using your tax case as an example, Adam, you get your instructions from your client. You don't actually know how many documents or how many transactions are going to be involved in the matter when you first presented with the matter by your client.
Maybe at the very, very start. Yeah, I would agree. It's difficult. If you don't know much of the facts, you're just going off what the client's told you.
And that's when the law says that you need to provide your estimate. So from that point of view, that's why I say to me it can be very difficult to be accurate at the beginning of a matter.
Yeah, but I think there are some things that you know. For example, you'll know that if you have a trial, roughly you could probably guess the number of days. You know counsel's daily rate, and you know they might require the same number of days to prepare. You know that you're probably going to, as a solicitor, have the same amount of time. You can at least estimate the trial. And then when you're doing evidence preparation, that's difficult at first. Some of this stuff depends on the behaviour of the other side. But when you see how many documents there are and you get a sense of the case, you could probably estimate some of that stuff reasonably accurately, I would think.
I think you're right. And I think what you said about the other side, not knowing what approach they are going to take is also a big factor. If you come up against a client that refuses to cooperate at any point throughout the proceedings, that's going to add substantial cost to your proceedings. They might file 4 or 5 notices of motion. You go through discovery. There are a lot of costs that can be added to your basic, let's call it skeleton of a matter. So your skeleton might be worth $100,000, but that can be, tripled or more quite easily by another party that isn't cooperative, or perhaps are even obstructive to you achieving the outcome that you're seeking.
Well, let me ask you the question another way, because you've done this on a couple of occasions. If I asked you, here's a matter, how much you think it's going to cost? You've seen so many bills over 20 plus years. Do you think that you could guess how much it could cost roughly, reasonably accurately?
I think I could probably estimate what I think a lot of matters are worth, whether it be $100,000 or $150,000. I think once a matter gets bigger and has more complexities in it, and has more evidence, more witnesses perhaps, it becomes very difficult to estimate. It could be hundreds of thousands of dollars, it could be over $1 million. It does largely depend. If you happen to have an opponent on the other side, another person who doesn't like you, or perhaps is just angry about being in the litigation, it can blow out quite a lot, just through various different stages. They might want to appeal every single decision that's made. You might end up going to the Court of Appeal. You might end up going to the High Court. There are a lot of things that can happen that can increase costs, which, at the beginning of the matter, a solicitor cannot reasonably see that, and that will only play out as the matter goes on.
Okay, then let me ask you this. Do you think a good senior counsel would be able to predict roughly how much a matter would cost?
I don't think a good senior counsel's interested in that, so probably not. Legal costs are not something, as a rule, counsel it's not part of their job. They don't think about it. All they do is issue their invoices, and that's about all they think about, issuing invoices for work they've done and getting paid. They're not too fussed about all that other stuff.
Okay. So, let me ask you this then. Do you think that solicitors underquote?
I think they do, yes. On average, it's a business tactic, in my view, to win the work. Once they've won the client, then the matter will play out as it plays out. I mean, their main objective at the beginning is to win the client. So you would be reluctant to say to a client, oh, I think this is going to cost you $500,000 when you don't have to. Because a lot of clients are just going to go, oh, that's a lot of money, and they're going to walk out the door.
And when they walk out the door, do you think they'd go to another solicitor, or they might say, you know what, maybe it's not a smart idea for me to fight this person?
Well, they could think both. They may not have a choice. I mean, if they're a defendant, they might have to be forced to engage a solicitor to help them. But they're not going to engage the solicitor that tells them that's going to cost them $500,000. They're going to engage the solicitor that tells them, oh, we might get out of it for $20,000 or $50,000. I mean, who would you go with? I know who I'd go with.
I mean, I've found consistently through life, it's not just with solicitors, but anytime someone is super cheap, it is always a problem. You know, I remember my mum found some random guy who was a builder or something. He offered some really ridiculously cheap quote to do a retaining wall, and he took the money and just ran off.
Okay.
It's just not realistic that it's going to cost that amount. And you got to ask yourself, is it really going to cost this much? What's realistic? I mean, if I went to a lawyer, you're right. If someone said I can do it for $20,000, another person says $500,000. I think there's another layer of analysis after that, because it's not the case that they're going to say, I'm going to charge you $500,000 to do the same work that the $20,000 person would do. They might say, well, there are 5 stages of this. You're probably going to go through all 5 stages. That's $500,000. But the first stage is $20,000, and the other lawyer might say, well, I'll solve it at stage 1 and it's $20,000. But if they don't tell you that there's going to be more costs if it goes to stage 5, you'd be thinking, well, at least one person is honest.
You would think that, and we are using extreme examples where we're jumping from 20 to 500,000. Perhaps we could use something more, 50 or 100,000 as an example. Again, would you go to the $50,000 offer, or would you go to the $100,000 offer? I think you'd go to the 50. As long as everything else was even, you'd go to the $50,000 offer. That's just human nature. It's like buying your Ferrari. Do you want to spend $100,000 on a Ferrari, or do you want to spend $200,000 on a Ferrari?
So then, do you consider that it's the solicitor underquoting, or really it's just the market's fault? It's the customer's fault for being cheap.
Well, I think it's both.
Okay.
I mean, it's a free market, so people are trying to win work. And once they've won work, then they're locking away their $50,000, and then perhaps the matter's solved for their $50,000. Perhaps it's not. I think that the example you gave, where there's 5 stages in the matter, and the first solicitor says, well, maybe we can solve the matter, in stage 1, i.e., work out what the claim is and how much it's worth, and settle it for a reasonable figure. And that might only cost you $20,000 to work all that out. If you go further, and then once you start proceedings, that's going to cost more money. Once it's defended, it's going to cost more money again. And then what happens after that? You've got to put on your evidence. Well, that's going to cost more money again. There might be, motions or interlocutory hearings about different things, such as a security for costs application. That's going to cost more money again. We might want to strike out the part of the cross-claim. Well, how much do you think that's going to cost? Is that going to cost another $50,000?
You're using very interesting examples.
Yeah, well, there are a lot of different possible ways a set of proceedings can go, and each different direction they go in, it costs more money.
Yeah.
And as I say, you don't know at the beginning of the matter that this cross-claim part of this cross-claim is going to get struck out. You don't know that. So you can't, tell your client, well, I think we're going to put this cross-claim on, and I think it's a good cross-claim, but the other side, finds a little sort of hole in it, and all of a sudden everyone's having a big argument about the cross-claim.
We are diving into the weeds a little bit there, because we're going to specific examples, so I might try to bring it back to something more general, because I think I agree with you that I think there is a lot of underquoting. But I also think that you're right. Some of it is based on, well, people being worried about the client going to someone else if they don't do it. But I think there's also a little bit of a disincentive as well to resolve matters, because I think if you take each party in a dispute separately and look at their own individual interests, it comes to a very startling conclusion. So let's say you have a plaintiff, you've got a defendant, you have a plaintiff's lawyer, you have a defendant's lawyer. Now, obviously, the plaintiff's lawyer is trying to get the plaintiff to win the case, and the defendant's lawyer is trying to get the defendant to win the case. So they have a shared interest in both of them with their clients in terms of trying to get the best possible outcome. But the two lawyers also have a shared interest with each other as well, a separate one, a commercial interest, because if they both rattle the cage at each other, saber rattle, do all this unnecessary posturing and things like that, and everything that comes with it, both of them get more fees. And so they actually have a commonality with each other, which lends itself to not necessarily settling the dispute, and in fact perhaps entrenching it. The only two people who really are truly on the same page on that score then is actually the plaintiff and the defendant, who are probably not talking to each other, but they have a common interest in resolving the dispute, because like in any kind of battle, the lawyer might be the person who's selling the weapons, and you might be getting great weapons, but at the end of the day, everyone ends up losing, and the weapons seller is the one who makes the money.
Well, that's the way it works, isn't it?
And the weapons seller might say, look, I'm going to sell you these weapons so that you can win it more easily, and maybe those weapons do help, but the other person's one's going to do the same thing, and they're not going to make any more sales if there's no more fighting. So I think there's actually a difficulty there. Now, I'd ask you this question. Do you think that there are lawyers who will deliberately, or maybe not deliberately, but just not necessarily put in the full effort to resolve a dispute because their commercial interests are not aligned with that being the outcome?
I certainly think there's an incentive for lawyers to operate that way. I can't categorically say that I've experienced lawyers acting that way. It might appear possible when you look at their files. You think, well, he or she could have gone left, but they chose to go right. Why did they do that? Perhaps that's the reason. But I can't say that I have ever had any proof of somebody acting in that manner. I think it makes common sense that there is an interest in a lawyer prolonging a dispute, because whilst ever that dispute is going, they're making fees, and at the end of the day, it's a business. So one would think that is an unnatural incentive for them.